Good afternoon. Welcome to the Heritage Foundation and our Douglas and Sarah Allison Auditorium. We, of course, welcome those who join us on our heritage.org website on all of these occasions. Do ask the favor of everyone in-house to check that cell phones have been muted as we prepare to begin. It's always appreciated by the speakers. And, of course, we'll post the program on the Heritage homepage following today's presentations as part of our Preserve the Constitution series. We also take this time each fall to reintroduce or introduce our audiences to the Heritage Signature publication, Heritage's Guide to the Constitution, which we do have available. It is a unique book in that it looks at each clause of the Constitution, clause by clause, and discusses the founding and how those clauses were viewed and how they have affected judicial decisions. Hosting our program today is Elizabeth Slattery, Legal Fellow in our Meese Center for Legal and Judicial Studies. Her research focuses on issues such as the rule of law, the First Amendment, civil rights and equal protection, and the scope of constitutional provisions. She also studies and writes about cases before the Supreme Court, judicial nominations, and the proper role of the courts. She manages the Meese Center's appellate advocacy programs as well, including our moot court sessions to prepare litigators for oral argument in important cases pending before the Supreme Court. Please join me in welcoming Elizabeth Slattery. Elizabeth?
Thank you, John. The Supreme Court's 2014 term was one for the history books, with cases such as Obergefell versus Hodges and King versus Burwell that generated a lot of interest from both the media and the general public. The court's next term begins in a couple of weeks on a Monday, October 5th. It may be a tall order for the court's docket to match the excitement and media flurry of decisions such as the same-sex marriage case and the Affordable Care Act decision of last June. But the justices have already agreed to hear a number of important cases involving affirmative action, voting rights and redistricting, and public employee unions, to name a few. To discuss these and other cases, we're fortunate to have with us today two of the top Supreme Court litigators around. In order to get to our panelists, I'll keep their introductions very brief. Lisa Blatt is a partner at Arnold & Porter, where she heads the firm's appellate and Supreme Court practice. She has argued 33 cases before the Supreme Court, prevailing in 32. She spent 13 years in the Solicitor General's office, working under 6 different solicitors general over the course of 3 administrations. She teaches appellate advocacy and procedure at the Georgetown University Law Center. Lisa clerked for Justice Ruth Bader Ginsburg of the U.S. Supreme Court. She received her bachelor's degree from the University of Texas at Austin and her JD from the University of Texas School of Law. Lisa has been called a visionary, and Washingtonian magazine named her one of the 100 most powerful women in Washington. Paul Clement is a partner at Bancroft. He served as the 43rd Solicitor General of the United States from 2005 to 2008. He has argued more than 75 cases before the Supreme Court. In fact, Paul has argued more Supreme Court cases since 2000 than any lawyer in or out of government. Paul clerked for Judge Lawrence Silberman of the U.S. Court of Appeals for the D.C. Circuit and Justice Antonin Scalia of the U.S. Supreme Court. He received his bachelor's degree from the Georgetown University School of Foreign Service and his JD from Harvard Law School. Justice Elena Kagan once described Paul as someone who brings electricity to the podium, and Nita Totenberg has described him as a wunderkind and a walking superlative. With that, Paul, can you kick things off and tell us about the Friedrichs case?
Sure. Well, thank you. It's great to be here. Great to be back with all of you, and great to have Lisa up here as well. This should be a lot of fun. So I'll start talking about the Friedrichs case. This is the big public sector union case on the court's docket, and this case really has its origins in 2 previous Supreme Court cases. The previous Supreme Court case, the continuing validity of which is really teed up for the Supreme Court in this case, is called Abood. Abood is a case from, I think, the 70s that basically held that in the context of a public sector union, it was permissible to have an agency shop law, which basically means that members of the public sector union or even objectors had to pay for essentially the union fees, and that they had only, the First Amendment gave them only a right to opt out of the portion of the fees that went to sort of First Amendment activities. And so since then, that's been sort of the prevailing doctrine You can have an agency shop in the public sector, and you have an opt-out right, but that's where things stand. The second Supreme Court case that sets the stage for Friedrichs is really a case from a couple of terms ago called Harris. And this was a case in which the Supreme Court addressed a public sector union case, and they specifically addressed the question of whether some personal assistants who were involved in in-home care were covered by the Abood doctrine. And the particular employees in that Harris against Quinn case were pretty far from sort of the epicenter of what you think about as a public sector union member, and so the court was able in that case to decide a case in the way that said that these particular kind of employees, because of their nature, were not essentially covered by the Abood doctrine. But if you look at Justice Alito's opinion for the court there, at least as I count it, the majority spent 9 pages talking about the personal assistants and 12 pages talking about how problematic Abood was. And so the signal to the bar that Abood was potentially on life support and that there may be 5 votes to overturn Abood was crystal clear. And so the lawyers in the Friedrichs case actually sort of took up that invitation. This case arises in probably a more classic public sector union context, which is school teachers in California. The litigation strategy here was kind of interesting because the lawyers went into district court and said, you can't rule in our favor because of Abood, so don't even try. Just let's get out of here as soon as we can. And the district court took them up on that invitation. They got to the Ninth Circuit. Now think about this one. This is an interesting dynamic. So the party that lost in the district court goes to the Ninth Circuit and says, you can't help us either because of Abood. And let's not even bother with like the charade of an oral argument, okay? Let's just get this going. And the appellee who won below said, no, let's have an argument. Let's brief this thing and let's talk about this. And the Ninth Circuit said, no, we're not, that if the appellant doesn't want oral argument and sort of concedes that Abood controls, then we're not going to bother with that. So this case really was on a sort of express track to the Supreme Court, and the Supreme Court took the case and really tees up 2 issues in the case. One is the validity of Abood and whether you can have an agency shop in the public sector context at all. And then as sort of a fallback position, the petitioners have also said that, well, if you're not going to get rid of Abood entirely, you should at least make it an opt-in regime rather than an opt-out regime. I think either one of those holdings, if the court were to accept them, would certainly be, I don't want to say a sort of death blow, but certainly a serious have serious ramifications for public sector unions. I think it's fair to say. I think people on both sides of the debate would agree that the stakes here are quite high. I also think in light of the Harris decision, that the chances that the Supreme Court will be willing to reconsider Abood here are pretty high. I think one way to think about the issue here is that if you use the Harris against Quinn case as your guide, then you would think that the swing vote here is Justice Scalia. And I don't know that that fact would really warm the heart of me if I was a public union official. And I say that less because you might think that Justice Scalia doesn't have an instinctive sympathy with the public sector unions, but it's more like, we're talking about a judge here in a First Amendment context who has voted in favor of flag burners and the purveyors of violent video games. And so, he has not really ever, I think, shied away from embracing a First Amendment argument, even in contexts where it, might have made him uncomfortable as a policy matter. So the idea that, Justice Scalia is going to be is going to reject the First Amendment claim here on the assumption that the Chief Justice, Justice Kennedy, Justice Alito, and Justice Thomas are all embracing the First Amendment theory, it's certainly possible. But I think in terms of thinking about the prospects of the court actually ruling Abood, I think that's a good way to think about the issue and makes it clear that the public sector unions in this case definitely have their work cut out for them. I would say one last thing about it, which is, as you can tell from the procedural history, this was a case that was really sort of hand-selected to take this issue to the Supreme Court. And in this way, I think it is a well-designed case to put the issues in a context that is favorable for the challengers, because if there's a middle position here that might appeal to Justice Scalia, it would be the middle position that says, look, of course, when they're involved in real First Amendment activity, political campaigns, things like that, then that's where an opt-out or an opt-in right sort of applies. But there is some sympathy, I think, traditionally on the court, and I think still a little bit with Justice Scalia, to this notion that, but there's also a free rider problem here, and to the extent that union members are getting the, non-union objectors are getting the benefits of the collective bargaining process and getting better wage conditions and better work conditions, there's something unfair of allowing them to sort of opt out of that entirely. I think if this case came up in the context of somebody like, people who were working in the vehicle shop at a state police department or something, then the kind of mix of political issues and labor issues, I think, might be quite different. But I think, one of the arguments that the petitioners make is that, at least in the context of public sector teachers, it's all political. I mean, the question of whether you have pay for performance in a school district is itself a profoundly important policy question that people care deeply about. It's also just the flip side of the labor conditions. And I don't think that's true of all public sector employees, but I think it probably is largely true of the public sector employees. So if you're thinking about this from the labor union perspective, they have at least two hurdles to climb here. One is that, they're looking at the court and looking at Harris. They sort of have to get Justice Scalia's vote, presumably, to win, which is tough enough. But then they're also facing this issue in a context that was pretty much handpicked by the challengers, I think, to take the issue on which Justice Scalia might be sympathetic and make it, relatively difficult to see a clean distinction between union activity and First Amendment activity.
Thanks, Paul. Lisa, do you have anything to add to that?
No, I agree with what Paul said. I presented on this case just last week at Cato, and my only hard time getting a handle on it is only the briefs supporting the challengers have been filed, so there were no briefs on the other side, no amici, and it looked pretty bleak for Abood just with that presentation. And so, I'm curious to see what they're going to come up with. They've got to be, I don't know what they're thinking. The only sort of line that I thought that, and Paul basically responded to it, but it's not in a great context, is the notion that their big argument, the challengers, is that there's no difference, that all collective bargaining issues are inherently public. So it's no different than lobbying, because how much money we spend in the public sector is uniquely political. And then the Michigan and I think 18 other briefs, which is also not good for the challengers, filed saying, go ahead and strike this. And that brief brings up the bankruptcies of large municipalities and says this is what happens and this is why it's political when you get bloated pension benefits. The one response they had, and it doesn't apply so much in the teacher context, is it's kind of a little bit disingenuous that these people are complaining that their wages are too high. It's not that simple in the teacher context, but if you're just talking about whether your wages should be $6 an hour or $9 an hour, the challengers look a little bit whiny, but I don't know what else they're going to come up with.
Okay. Do you want to tell us about the Fisher case now?
Oh, I'm presenting on Fisher?
Yeah.
I didn't know that, but that's fine. I'm happy to talk about Fisher. As a University of Texas undergrad and law school grad, I've been following this case, I guess since the time of Sweat versus Painter. No, I'm kidding. So it starts with this case called Hopwood, which was, I think I had just started in the SG's office, and I was in Paul's old office, and Drew Days was there talking about the decision and basically reading it. It had just come down. And so that's my familiarity with Hopwood. But it basically was the Fifth Circuit striking the constitutionality of a race-based admissions program. And Texas responded to that with the top 10% plan, which, I don't know, I thought it was brilliant at the time to take the top 10% of every high school. And I guess that brought in maybe, 80% of the class at Texas. And it's changed over the years. Now it's only like 60, 70%. Texas was not particularly happy. It turns out that, I know this is a big surprise, but neighborhoods are somewhat segregated in Texas, and it was not, and part of it, it helps to have gone to Texas. It's not very diverse. It's got a ton of Hispanics, proportionally 20 to 30%, but African Americans were something like, 4% one year, and it's law school. It was pretty bleak too. So they added, at a time they started, I don't know when they added it, but certainly by the 2000s, actually it was right after Grutter, the Michigan affirmative action case that said it was okay as long as it was holistic and you didn't look too carefully, you'd look at race, but not maybe say how much you looked at race, you kept it sort of vague, it was okay. So they added a race-based admissions on top of their top 10% plan. Abigail Fisher, who's white, was not let in, she challenged. These challengers are the same challengers that are bringing the voting rights case that I'm going to talk about. So it's Burt Ryan and Will Consovoy, also the people who brought down the Voting Rights Act. So definitely test case in mind, I would say. The Fifth Circuit upheld it. It went to the Supreme Court. This was at a time where the Voting Rights Act was being struck. I forgot what else was up there. And I said somewhat cynically, the court just didn't have their stomach to vote against black people that many times that term. They just got to the end and threw up their hands and had a 2-page decision saying, this is supposed to be strict scrutiny. You put too much, Fifth Circuit, it was an opinion written by Judge Higginbotham, you put too much deference into the University of Texas, go back and do it again. So I filed a brief in favor of the University of Texas for the American Psychological Association and plan to do so again. I took it seriously. The court said go back and do it again, and so the court went back and did it again and came up with the same result. Texas has lots of arguments, and we'll talk about that. But so the court granted, which surprised me, but surprised nobody else. I think everyone predicted the court would grant it but me. The basic argument of the challengers is that you have your top 10% plan, and now you're stuck with it. In some sense, this case, I don't think puts the fear of God in every other university because they don't have the top 10% plan. And the basic argument is this is a race-neutral alternative, and what Texas is trying to do, Texas does not agree with what I'm about to tell you, but the Abigail Fisher says what Texas is trying to do is to bring in people who can't get in because of the top 10% plan, because they come from well-off neighborhoods. And so I think at the oral argument, I don't know if it was in Africa, or at least in the briefs, it was the specter of African-American, BMW driving African-Americans, and that's who Texas wanted to get. The bottom line, though, with Texas, and just to look at their admission policy, it's obviously more complicated than that. But the biggest problem is that it's just a complicated system. The court in Bakke and Grutter has not given much guidance. They've said you can do it for critical mass. Nobody knows what critical mass is. So Texas, on the one hand, gets criticized for looking at race, and on the other hand, they say it's not very effective because you're not letting in enough people to make a difference. You're still basically where you were back at the time of the top 10% plan. So we'll see what happens. I think the more interesting case is the case that same challengers, Will Consovoy brought against Harvard on behalf of Asian Americans. That presents a more traditional, interesting, and exciting challenge. For those of us who went to state schools, I also feel better that they're going after the Ivy Leagues instead of picking on the state schools. They're the people who actually, it's more important, and they have a harder time. So we'll see what happens. But I think from the school's perspective, every other school but UT, they just don't want to see Grutter overruled. And I think the question is Texas going to get told to do it again or just stick with 10%? Are they going to affirm it, which seems, we'll see, or will they just overrule it?
Thanks, Paul. Any comment? Nope. Okay, let's move to voting rights and redistricting. Paul, do you want to talk about the Harris case?
Sure, I will. So the Harris case is the case arising out of the Arizona Independent Redistricting Commission. Despite my best efforts, there still is an Arizona Independent Redistricting Commission. I was kind of hoping this case would be sort of mooted or something as a result of a challenge to the creation of the Arizona Independent Redistricting Commission, but the Arizona Independent Redistricting Commission, sort of the on the one hand, the Arizona Independent Redistricting Commission still exists. On the other hand, if the proponents of that so-called independent commission thought they were going to solve all the problems and there wouldn't be any Voting Rights Act disputes about their work product, they were wrong, because their work product has made it to the Supreme Court in the form of the Harris case. There are two questions. There was originally a third question that was maybe more of a traditional sort of Voting Rights Act, were the districts drawn in a way that was too favorable for Hispanics and all the rest. But the court, having granted momentarily all three questions presented in the appeal, then had a subsequent order and made it clear they were only going to look at the first two questions in the case. I think both of them are potentially interesting. I don't think this is the more important of the two cases we're going to talk about, so I'll be brief. But they are potentially important questions. I think one is about the so-called safe harbor for population deviations and the extent to which you can bring a claim against a state in its redistricting process for population deviations that fall within the safe harbor. Just to take a step backwards here, there's this interesting kind of anomaly in the court's one-person, one-vote doctrine, which is that while at the federal level, the expectation is that there be essentially no meaningful population deviations. When it comes to state redistricting, so for the state house, state senate, things like that, the court has traditionally allowed with sort of a de minimis differences in population, but the de minimis differences in population can actually be quite significant. Sort of traditionally, the courts have suggested that there's a presumption that there's not a constitutional problem if you're within sort of 5% either way in population deviation among districts, which if you get 5 one way, 5 the other, that's a 10% deviation, and that's sort of loosely referred to as the safe harbor. And one way of thinking about this case is how safe is the safe harbor? Because on the one hand, the districts as they're drawn in Arizona are well within that safe harbor, but on the other hand, there are significant deviations in population. And if you think about, why is there a safe harbor at the state level but not at the federal level, there are constitutionally based reasons for that distinction. But there also, I think the idea originally was that at the state level, in particular, you had sort of traditional state doctrines that said you don't draw a district line across a county line and things like that. And so I think there was an interest in trying to give a little more deference to those kind of state judgments. But I also think at the time that the court was doing most of these decisions, the ability to draw lines was a little more rudimentary, and the use of computers was, a little less advanced. And so you now have this situation where, at least, hypothetically, a district could get, to 4.99% below the average in one district and 0.499% above the average in the other direction, really kind of maximize the ability to use the safe harbor. And what is particularly at issue here is whether you can have deviations within the safe harbor if the only justification for them is partisan politics. And again, that's the allegations. There's a whole bunch of factual disputes. The appellees will tell you that the factual issues here don't even give rise to this issue. But that's one of the issues that's presented. And I think it is an interesting question because the court has struggled and really hasn't been able to come up with a workable doctrine for partisan gerrymandering. But this would be one way to try to have at least one rule about partisan gerrymandering that at least seems administrable, which is you can't deviate within the safe harbor ranges for purely partisan reasons. The second issue really gets at, I think, another interesting issue because one of the other justifications, there's a dispute between the parties about how much partisanship was involved, but there is no real dispute that one of the reasons that the commission drew the lines they drew was to sort of smooth the way to Section 5 preclearance approval at the Justice Department. And the question posed by this case is, to what extent is that a legitimate interest that justifies population deviations, especially in light of Shelby County? And so that's the other issue that's lingering in this case. So I think both issues are reasonably interesting and important, but I think they pale in comparison to what Lisa's going to talk about.
You want to tell us about Evenwell?
Yeah, I first wouldn't mind a show of hands if anyone understood what Paul said.
Hey, that's me.
Okay, good. So I've now sat through 2 panels with somebody else presenting on Evenwell and didn't understand a single thing they said because I was not familiar with voting rights. So I'm going to do this at a much, assuming you all are as dumb as I am, and if it gets too boring, say, Lisa, you can speed up. You obviously know math better than I do, because I'm going to talk about math, and then you can explain to them what it means, because there's math in this. I'm counting on you. I had trouble with even one person, one vote, but apparently that's what this case is about. A concept that apparently started in Reynolds versus Sims in 1964. Am I already boring you? No? Okay. One person, one vote, and just bear with me if I'm reading a lot of my notes here, ensures that equal numbers of voters can vote proportionally equal number of officials. And so when Paul talks about this, about voter population, I think there's this question that I never focused on, is how you're counting population. And this is involving a state districting, I'm correct, hopefully out of Texas. Their Senate districts, there are 30 or maybe 31, and this is how they're divided up. You can either do total population according to census, and apparently you draw this up after the 10-year census. You can do it by citizen population or by population of eligible voters. And how you go about doing the eligible voters, I think, is subject to some dispute. And this is all straight out of the court's cases. This is not a problem usually in terms of how the population is, whether you use total population or voter population, is because the number of ineligible voters are usually spread out evenly among the eligible voters. So really doesn't matter if that's the case. Anytime it varies, though, there's dilution and trade-offs. Whether you want the right to vote not being diluted, or you want an equal number of representatives that are proportionate to your total population. You got that? So we're looking at representatives versus the eligible voters. How much is his or her vote counting? Reynolds versus Sims, I said, was in 1964. A case came out 2 years later, Burns versus Richardson, and I just think the facts here are very interesting, so I'm going to tell you. In 1966, Hawaii drew its districts by eligible voters, and the reason why is because it had a large population of people in the military and tourists who weren't eligible to vote, and because it was so out of whack, they did it by eligible voters. And the court said that was constitutional, and here's the language that created where we are today. Said, for purposes of apportionment, quote, the decision to include or exclude aliens, transients, short-term or temporary residents, or persons denied the vote for conviction of a crime involves choices about the nature of representation with which we have been shown no constitutionally founded reason to interfere. And so that's been the state of the law, I think, that it was just basically up for grabs. And, the reason why I think that I find the Voting Rights Act so elusive is there actually is nothing in the Constitution that says you have a right to vote. There are 3 amendments that presuppose it. The court has said it's a fundamental right, but it's not like there's a constitutional text that talks about the right to vote. So there's all these strange doctrines that come up by virtue of just case law. Justice Thomas, in a decision, and I don't have the year in front of me, Paul, maybe you know it, Chen versus City of Houston, was it like in 2000 or something, or maybe 2006?
2001.
2001, dissented from the denial of certiorari, saying we should really look at this and try to figure out or give the court some more guidance on how you count your populations. So here we are in Texas. Another test case brought by, again, Will Consovoy, same guy who's bringing the case by Asians against Harvard. Yes, and also the Fisher. Their districts are based on total population, and here's Paul where I need you, but they are grossly malapportioned in terms of eligible voters with deviations from what is known as an ideal district by 46% to 55%. Do you understand that?
Sure.
What does that mean?
That just means that because they either have like a really disproportionate number of children in one district or a really disproportionate number of ineligible voters.
It's rural versus urban here.
Yeah, I mean, you just have radical differences when you compare the number of eligible voters in this district versus that district.
Well,
but if you look at not eligible voters, but population,
it's even.
They're within the safe harbors.
Okay. So that's the issue, is whether this is okay. Apparently, these deviations are so significant. If Paul was talking about 5, even I get that 55 is larger than 5. And so does that sort of, forget it, this so dilutes Evenwell's right to vote. The only other sort of interesting, because I'm always more interested in the drama and what's going on behind the scenes, I have this little fact for you. The Solicitor General's office in 1991, the Ninth Circuit had issued a decision, I'm pretty sure it was upholding total population, Garza versus County of LA. I don't know who brought the petition, but the government, and Judge Kaczynski wrote a very lengthy, I don't know whether it's dissent or concurrence, which is getting cited all over the briefs. But the government, in its brief in opposition to the court, endorsed state choice and said this should just be a matter up to the states. The Ninth Circuit had held that even if you're an ineligible voter, there's a right to this representation, and said at least either it held that total population was required, or at least in some instances. The Deputy Solicitor General in that case was John Roberts. So if the government deviates from this position, I think that the chief will notice.
Interesting. Paul, do you want to tell us about the Article 3 standing case Spokio?
Sure. This is a fun case because it's a great sort of Fed courts Article 3 question, and it also has a lot of practical importance. So this is, loosely speaking, this is the question of whether Congress can create an Article 3 injury for somebody who's not really injured. That's a weighted way of putting the question, but I think that really gets at the heart of the question, because you have a number of federal statutes, and this case arises out of the Fair Credit Reporting Act. But you have a number of federal statutes that provide for sort of rights that can be violated in ways that don't create a super obvious kind of personal injury for somebody, but nonetheless, if you are a victim of the statutory violation, you can bring a claim for statutory damages of, typically around $1,000 a violation. And particularly if you start to get a bunch of injured people together and all of them can collect $1,000 per injury, it starts to get pretty interesting from a standpoint of bringing a potential class action. So there can be real money in injuries that don't, seem like the kind of classic Article 3 injuries where somebody's lost Blackacre or is lying bloodied in the street. Those are all like, yeah, okay, there's your Article 3 injury. Injury in fact, yes, you're on the sidewalk. That's injury in fact, or you've lost your house or whatever. But if somebody, took the, absolutely outrageous step of reporting the last 5 digits of your credit card on a receipt instead of the last 4, which is permitted, and therefore violated the Fair Credit Reporting Act, or on some form that really didn't lead anywhere, reported some inaccurate information about you. So, at some level, it sucks, to use a technical term, that there's some credit report, out there that says that you have an outstanding debt that you don't. But if you weren't denied credit on that basis, we would appear, at least at first blush, to lack the kind of classic Article 3 injury. But nonetheless, Congress says you're entitled to $1,000. And if you take $1,000 out of my wallet right now, that's an Article 3 injury. So that's really, I think, the question that is at the heart of this case. And it's a hard one. Because, if you go back to the sort of first doctrines on this, before the kind of modern injury in fact tripartite sort of analysis of standing, the classic formulation of when you were injured was when you had an invasion of your legally protected interest. And from that way of looking at it, which is a pretty traditional way of looking at standing, then, Congress ought to be able to create Article 3 injury by giving you a legally protected interest. I have a legally protected interest in having sort of only the last 4 digits of my credit card on a receipt. Is it the most important thing in the world? No, but it's kind of cool. It's a legally protected interest. And so the question that the court will be facing here is that enough? And if they decide that is enough, then that's a straightforward way to resolve the case. There are also a lot of subsidiary questions that get, I think, borderline metaphysical, which is, if they say, well, that's not enough, but the plaintiffs here aren't crazy, so they're not relying exclusively on the statutory sort of injury. They're saying, no, we actually had other injuries here, and, I was out of work at the time, and so my unemployment is an injury, or, one of the things that was misreported was marital status. Now, I don't know that got to anybody that the person was interested in dating, but you can imagine where you can start to sort of claim that there are things in addition to the $1,000 of damages under the statute that look more like a traditional Article III injury. And I will say that the particular facts of this case, I don't think are perfect for the court to decide this issue. Because, I think, it would be nice to have something where it was sort of 4 out of the 5 digits and it really came down to that. But this is an effort, the Spokio is some kind of, internet-based information reporting agency. It's not 100% clear. They're even sort of covered and fall within the heartland of the Fair Credit Reporting Act. So the court, maybe one way to put it is stretched a little bit to take this case and, take this issue up in this case. I think that shows they're really interested in it and they find it interesting from this kind of basic Article III. A lot of these justices used to be law professors. I mean, this is kind of really interesting stuff in a law geek kind of way. It also has tremendous practical importance, and that's the thought I'll leave you with, because and really this is where the tremendous practical importance really turns on not just what the bottom line in this case is, but how the court decides this case. Because if you say that the statutory recognition of a right combined with the statutory right to damages is enough for Article III injury, then the plaintiff's class action bar is going to be very happy. Because what that means is they won't have to prove that individual class members were actually injured, and they won't have to prove individualized damages. And if you think about the court's class action jurisprudence in recent years, I mean, individualized issues like every individual member of the class has to prove how they were injured, and even every individual in the class has to show their individualized damages, those will come pretty close. The former probably completely precludes a class action, and I think that it's even arguable that individualized damages can preclude a class action. So that's why, in addition to a couple of briefs on both sides by law professors, you also have like a dozen amicus briefs on both sides of this case, because the difference between saying that there's a pure sort of statutory cause of action, statutory damages are sufficient for Article III purposes, that'll give a green light to class actions under these statutes, even if they were to rule in the plaintiff's favor, but to do it on the ground that, well, here there was enough individualized injury, that's going to make class actions in enforcing these statutes much more difficult to pull off.
I mean, Paul and I could probably talk 3 straight days about this case. It's by far my favorite case. It was also my favorite case when it was briefed and argued 2 or 3 terms ago. What was that, Edwards? Financial something versus Edwards. And that's a case that I think was argued in November, and on the last day of the term, when they decided Windsor, and maybe it was the healthcare case was the day before, I don't remember the order, the court just dismissed it as improvidently granted. And the rumors, and that's only guesswork, is because Justice Thomas was shy of an opinion from the November sitting that he was assigned the opinion but couldn't hold on to 5 votes. And if that is true, it doesn't surprise me. I mooted this case for Aaron Panner, who argued it for the bank, and they had to shut us up with questions because it was just endless. But the statutes, on the one hand, are very helpful for the pro-standing side because some of them sound so silly, like there's a bunch of them that are silly. I think I had one where it was a case I had in the Supreme Court, but the violation was you sent a reference to someone, but you forgot to put something on it, some disclosure, and they owed $1,000. And it was a class action, and it was beyond silly. But the government, both in Edwards and either they're doing it here, I'm not sure they filed the brief, but the big thing is the list of other statutes that start to sound maybe the justices would care about it. The one that kind of made me sort of ill was the Driver's License Protection Act. Like if somebody gives out your driver's license, that's one of them. And I'm thinking, oh, okay, I want to sue if that one's violated. The rest of them I don't care about. maybe robocalls I would probably want to sue too, but I don't know. But there are some, and then the other thing that was a little bit, there are two other things that the plaintiff side of this that got traction, and you could tell at oral argument, and I think kind of made people feel a little queasy, is sort of in the civil rights area. The best case the plaintiffs have is Haven's case with testers who sought information about housing, African-American testers, and were denied the information. They were testers, so they weren't injured. And the court said, oh, of course they have standing. And then just kind of blew right past it. The other one in sort of the common law, which is why this is why it's so hard, is because the plaintiffs are saying, well, you hurt my reputation. It was misinformation, therefore that's an injury like a common law. And the example they keep giving is the trespass. You stepped on my lawn and the grass immediately went back up. I still could get $1. And I think it's just the fault of the two different doctrines in the Supreme Court. And there's just so many cases saying you actually have to have an actual injury. And there's all these statutes. But there's like a list, and there's maybe like 15 of them that are mostly financial. But the ones that to me go to privacy are the ones that I start worrying about.
Okay, Lisa, do you want to tell us about some of the capital sentencing cases?
Yes, because we're not going to talk about the law. That's why. I was horrified when I was asked to talk about these because it's like, this has got to be really boring. There's actually two perfectly, kind of interesting legal issues that we'll talk about, but I don't want to talk about that yet. I want to talk about the crime because it was just incredible. So Kansas versus Carr, these two brothers had gone on a killing rampage, murder one day, maybe murder second day. But here's the murder on the third day. It's entitled in the state's brief, The Birchwood Rapes, Torture, Robberies, and Multiple Murders. I'm going to leave out all the sexual torturing and the rapes, and I'm just going to get to the more gruesome stuff. But so they repeatedly rape everyone. They'd make them all by gunpoint, take them down to their ATMs. And then when they were done with them, and this was after several hours, they forced all the men in the trunk, put two women in the back seat. They lined them up, and they executed them on their knees. One of the women was wearing a plastic hair clip, so the bullet kind of missed her brain, and she survived. But they weren't done. They ran over all four of the victims, literally ran over them. But she's still alive. So this is just the last sentence. I'm really sparing you the gross stuff. After the cars left the murder scene, Holly G got up, used the only piece of clothing she had in a futile effort to bandage Jason's fatal head wound. She saw lights from a distance, naked, barefoot, shot in the back of the head, and having been run over by a vehicle, she somehow managed to travel more than a mile through snow and over fences to reach the house. And I'm like, okay, I'm done. So, I'm done. It's just, this is a bad one, I think. And the other one I'm doing, the guy robbed a Popeyes. And so maybe all the capital cases are bad, but this one seemed particularly bad. Don't you agree? No? All right, anyway, here are the legal issues. And the only reason I say this is because last term, there was all this attention to a capital case where Justice Kennedy commented on solitary confinement. And then Justice Thomas, I thought, wrote a pretty moving opinion about, let's talk about the solitary confinement of the victim and what the victims must have gone through. So I hope that Justice Thomas skips the facts on that one. So they were tried together, the two brothers. I think Reginald is the older brother who was 25 and Jonathan is 20. And so their trial was joint, but Jonathan, the younger guy, basically was blaming everything on the older guy in mitigation, saying my older brother picked on me, he abused me. And so Reginald is saying, I had two prosecutors. I had the prosecution saying I'm a bad person. I had my younger brother saying I'm a bad person. And this is horrible. And the Kansas Supreme Court said, yes, let's reverse the capital sentences of both, and they get a new trial. And because their interests were antagonistic and it was unconstitutional not to sever. The other thing that happened in this case was, and just for those of you who aren't familiar with any capital, when you do the mitigation, you put on the aggravating factors. I can't imagine what these aggravating factors were, but presumably the state had some. And then you get to put on your mitigation defense, which can be anything to appeal to mercy. And no one really thinks about it. The charges are always you have to find one aggravating circumstance and then you weigh them against the mitigation. What the Kansas Supreme Court said was, and there's an argument about whether they said this was constitutionally required in all instances, but the defense wants an instruction to the jury, I don't have to prove my mitigation circumstances beyond a reasonable doubt. I can just prove them. I'd never even heard of that. I thought that was a little bit, I've never heard of a defendant asking for that, and it just seemed, I mean, Paul and I did a lot of criminal work together. So, you know, the court granted both of these. I think they're really tough cases for the defense. The defense brief starts out, this was a horrific crime, and then it goes to the law. The state's argument is that we have joint trials all the time in the criminal justice system. There's always going to be some antagonism. There's already a well-defined standard. It has to impose serious prejudice. The court kind of said in this case, it was just because of the two brothers. On the mitigation, the arguments are, and you can just think about it because we all could be on a capital, we could all be on a capital sentencing trial. Do we need that instruction? Are we unfairly prejudiced by not hearing it? Do we presumptively think the defense has a beyond a reasonable doubt standard? Or is it okay just kind of leave it up in the air? The state argues the jury had enough information. They just needed to know that mercy was an option and that they could weigh it. But anyway, all right, I can tell you none of you are moved by the facts.
Paul, do you have any comment on those or any of the other capital sentencing cases?
No, I mean, you know, just other than to say, you know, it's an interesting dynamic to be arguing capital cases before a court where at least a couple of justices at the end of last term basically said they might be off, you know, the capital punishment train entirely. So I do think that's, you know, an interesting dynamic for these cases, and I think.
Do you want to do it in this case?
Well, you know, but you know, I mean, look, this goes back to, you know, Chief Justice. Go read any randomly selected capital opinion, majority or dissent, by Chief Justice Rehnquist. You know, I would predict that, you know, the fact section will be longer than the law section. I mean, because, you know, this is the idea that you just start with the gruesomeness of the underlying crime is, you know, something that as a tool of sort of advocacy, it's certainly attracted the attention of Chief Justice Rehnquist and advocates ever since. So, you know, I do think in some ways you read those facts and, you know, it puts the justices who are ready to get off the train sort of, you know, to the test. But on the other hand, I think, you know, I don't think they're going to blink. You know, I think that they have plenty of reasons to think life in prison is pretty lousy too. So, you know, in terms of a punishment. So, I do think it will be just kind of an interesting dynamic.
I love that I'm to the right of you on this, Paul. This is fun.
No, I don't know if it's left right. I think it's going to be an interesting dynamic. You know, to see because you know this is the first time in a while I think that we've had a couple of justices, and you know, you could quibble. I mean, you know, I think they basically said I'd want this fully briefed, so they didn't get entirely off the train. They just sort of suggested that they were ready to look for a door, I guess. But you know, it's been a while since we've had the dynamic where you have justices up there that are, you know, pretty much off the train. I mean, because, you know, Justice Blackmun, you know, usually justices declare that they're done with the death penalty, you know, in their last term, late in their last term, which, you know, in an odd way though makes sense because, you know, it becomes a little bit harder. You know, you now have a court where a couple of people are just, like I said, they're sort of done with the issue, and you know, and I think it creates kind of interesting questions. Like, presumably, even though they're done with the issue at some sort of global level, they're not going to just sort of say, "I'm done with this," and so I don't even have to read the briefs. I think they're going to engage on the underlying issues and vote on the underlying issues. I don't know if they're going to vote. Like, I don't know if Justice Ginsburg or Justice Breyer is going to actually side with the defendants on one of these subsidiary issues. I assume they might. I mean, you know, the questions here, at least as you've teed them up, are kind of independent, really.
Yeah, they are.
Of what you think of the death penalty vel non. But I just think it'll be an interesting dynamic for the advocates, a challenge.
Yeah, I have one little war story. I don't know if I vaguely remember it was the case that Miguel Estrada argued in his first case out of private practice for a capital defendant, and he was getting into the argument. It was, I don't know, some kind of Brady case, and the chief interrupted and said, now he used a rock, right, to kill the victim. I mean, just as Miguel got going. Anyway, all right, no one thought that was funny. I thought that was
I did.
But that was his question, and Miguel kind of had to say, yeah, but okay.
So I want to leave time for questions with the audience, but there's one more issue that's coming down the pike that I wanted to get your thoughts on, Paul. The Little Sisters of the Poor.
You mean you're not going to let me talk about my FERC case?
I'm sorry,
Oh,
can we
man.
skip FERC?
People were clamoring for FERC. Give me more FERC.
Now
All
that
right.
there is a...
I'm sure there'll be questions about it. So,
Now that we have a circuit split in the accommodation cases, you want to give us a little bit of a preview on that?
I'm happy to. In a way, though, the circuit split sort of takes all the intrigue out of this, because I think it was a really interesting issue whether the court was going to take what we'll loosely refer to as Little Sisters of the Poor issue up, even in the absence of a circuit split, because until last week, essentially every court that had looked at this, the majority in those courts, had all said that there was no RFRA violation. There wasn't even a substantial burden on religious practice. Just to take a step back, for those of you that aren't familiar with it, the Little Sisters of the Poor issue is whether or not it violates RFRA to require certain religious employers who have not been exempted by the federal government to comply with the contraception mandate by putting and there are kind of different ways that they do it, but essentially by filing a form with the federal government that allows the contraception to flow to the employees, usually through some third party, either the plan administrator or an insurance company. And so this is the so-called accommodation. I don't think that's. I mean, I'm involved in these cases, so I'm take this with a grain of salt.
Which
but I
side,
think
Paul, are you on?
I'm representing the Little Sisters. I'm also representing a couple of Baptist universities in Texas, and so who are challenging this particular application of the contraception mandate. This is referred to by the government as an accommodation. We argue in our briefs that's a bit of a misnomer, but in all events, that's the issue that's presented in these cases. And it is, as I said, it was a very interesting dynamic in the lower court, because although up until last week, all of the courts that had addressed the issue had ruled in favor of the government and had ruled that there wasn't even a substantial burden on religious exercise, there were a lot of dissents along the way. And I think it was particularly interesting what happened in the 10th Circuit, which is there was a split decision against the religious claimants in that case, and the 10th Circuit had a vote on en banc sua sponte. So the parties in that case were, figuring the Supreme Court's probably going to take this issue, let's get our petition up there. So they didn't seek en banc in the 10th Circuit. But sua sponte, there was a vote on en banc, and 5 judges of the 10th Circuit not only did the kind of, sort of plain vanilla, hey, we would vote to rehear this case, we think it's problematic, but they basically went on to say, but, we don't feel so bad that the court didn't grant en banc because this decision's so wrong, it will not long stand. I'm paraphrasing, but that's basically what they said, which is, a bold prediction in the context of a case where at the point that was written by 5 judges on the 10th Circuit, the courts had all, by disposition, ruled in favor of the government and rejected the position they were kind of confidently predicting that the Supreme Court would embrace. So it was really interesting to sit around and talk about, are they going to, are they going to need a split for this, and will they take it anyways? The court had intervened 3 times in sort of emergency stay-type proceedings to favor the religious adherent in these cases, not in a way that was outcome determinative, but showed that they were focused on this issue like a laser beam, and that the court was not interested in allowing a decision to get to the point where a religious adherent would actually have to apply with the accommodation, at least as conceptualized by the federal government. So the court is very interested in this issue. I think there were reasons to think that the court would have taken the case even without a circuit split, but we'll never know. Because the 8th Circuit ruled in favor of the religious claimants, said there was a RFRA violation, not just a substantial burden, but ruled against the government across the board, entered an injunction against it in the 8th Circuit. And so, I would be surprised if the government, I don't know which sort of vehicle the government's going to try to steer the court toward, but I would be surprised at this point that the government really even resists certiorari. So I think there is an excellent, excellent chance that the Supreme Court will decide this case this term, and I think it will obviously be closely watched. It's a case that, I won't bore you with too much detail about it, but it's just very interesting because the claims of the religious adherents are basically that the government is making them complicit in the provision of the contraceptions. And the majorities of the lower courts and all of the circuits, except for the Eighth Circuit, they've all not been able to get their head around that, and they all have sort of said, wait a second, there's just too much attenuation here. All you're doing is providing this form, and this form, then kicks off a process that involves the provision of the contraceptions by third parties, not by the employers in any kind of direct way. And that's the issue that sort of tripped them up. And the response to that, which is I think supported by Supreme Court precedent in other contexts, is that's not really the call for the courts. It's not really the court's decision to say what degree of complicity makes you complicit. That's really for the religious adherent. But even though I think there's good authority for that in a Supreme Court case called Thomas, and in another Supreme Court case called Hobby Lobby, which has some relevance here, even though there's pretty good Supreme Court precedent for that, I think there's been a real sort of instinctive resistance of that among the judges that are hearing this, including some very conservative judges. I mean, I think most sort of eye-catchingly, Judge Smith of the Fifth Circuit, ruled in favor of the government in this case. And I'm not in the business of predicting judicial decisions, but I would have lost some money on that one.
I just wanted to say, just a quick thing, because this room versus this case, Irv Gornstein presented on in the DC bar, and this really plays into what Paul was saying. The panel members in the room, everyone listening, was like, well, what would be the argument on the other side? Like, what is their problem? And Irv, I thought, had a nice way of saying, this is a case where neither side gets what the other one is saying. It's like they don't understand, why they don't understand why the other person doesn't understand what they're saying.
Yeah, and the interesting angle on all of this is that is certainly true. I talked about accommodation being a loaded term, but one of the things that's interesting about this is that the government has sort of taken on its own initiative in this particular area the sort of felt need to say, okay, so if you're a church or certain auxiliaries of the church that are very closely related to the church, we're going to give you an exemption. And then it said, now for some of you other religious employers, nonprofits, we're going to give you what we call an accommodation. And then they've kind of modified that once or twice. But all of this is a little bit odd because this whole process of sort of doling out exemptions and accommodations is not really provided for in the Affordable Care Act. So it's all got this kind of ad hoc flavor to it. And, now this is maybe where, I'm sort of looking at this through the lens of my clients. But, there is this sense in which both sides are talking past each other. But I do think the mood music of RFRA is that it's not really for the federal government to say, look, why aren't you guys satisfied? I mean, we've done this thing. We all think that it totally solves the problem. We view it as nothing more than a piece of paper. We have lots of government forms. Well, what's your and I think that, as I say, sort of the mood music of RFRA is that that's not really the federal government's really doesn't get the last word anyways, and obviously the Supreme Court will get the last word. But on this question of whether we've kind of done enough for you.
Yeah, well, the government always underestimates challenges. It always thinks, these are all frivolous. Now, the only thing interesting about this and why these things are so interesting is I think Paul and I both recognize that at least the voting rights case and the standing case are hard cases. This one, I don't think people think of as hard one way or the other. That's all. The standing one is just generally hard because you can see the arguments and it's hard to figure out, okay, is there one little clear thing here we can do?
Yeah, no, I think that's a very astute observation. I think both sides think that the resolution of the Little Sisters case is straightforward.
But that was true with the other healthcare case of last term. There was nobody who thought it was a close call. Everyone thought.
Well, there were two people who mattered in the end.
Right, but I meant just people watching it.
Yeah, no, that's probably true.
Okay, now we have time for a few questions from the audience, so please wait for one of the microphones. Identify yourself and please ask a brief question.
And just so you know, both at Cato and the DC Bar, the audience asked about the FERC case, and nobody was prepared to answer the question, so now's your time to ask about FERC.
Yeah, though in fairness, you should feel free to ask a question about something other than FERC. I mean, if you have those kind of questions.
Down here.
People care.
Hi, Walter Weber from the American Center for Law and Justice. I have a question for Lisa about the race cases. They all involve state universities, but you said now there's a case against Harvard. What is the theory that brings Harvard into this?
I forgot what title, is it 4 or 6?
6 maybe.
6, sorry. It's spending clause. I assume federal aid, and these universities need federal aid. I don't know if the argument is, though, that the constitutional standard is any different when it's federal money versus state action. I haven't seen enough briefing because the complaint's been filed. So, but it is because they're, sorry, there you are, Walter. It is because they're recipients of federal money, and therefore, I don't know if it's an executive order or just the title itself says you can't discriminate on the basis of race. So he's just not bringing, I guess, a constitutional challenge as opposed to a statutory challenge.
Over here.
I'm Roger Clegg with the Center for Equal Opportunity, and that's right, it is Title VI. And Bakke was actually a Title VI case. So the Supreme Court has said for a long time that Title VI is coextensive with the Equal Protection Clause, and reaffirmed that in Grutter. With respect to the same case, the question of whether Grutter should be overturned is not in the question presented, but I wanted to ask you all as sort of, Supreme Court experts, whether it is still a possibility that the Supreme Court might go on and overturn Grutter because of, a few twists here. The court had said that Grutter was supposed to last for, 25 years, and we're halfway there. A lot of the Meeke filing briefs would like Grutter to be overturned. In Fisher 1, the original opening brief left the door open to Grutter being overturned, and then there's a question of why otherwise did they take it?
Well, I think they're mad at the Fifth Circuit, or at least the people voting to grant. But it's Justice Kennedy is the answer to, I think, all your questions. He, on I think it's at least 3 Supreme Court cases, has said he liked the Harvard plan, which had race-based admission. So I think at least the defenders are thinking Kennedy is not there, even though there may be 4 votes. In the briefing of Fisher 1, just ran a word search, the opening brief and the bottom side brief quoted Justice Kennedy's separate opinion 50 times each, and the reply brief, I think, may have been 35. So it's almost 8 of them should not even attend, or maybe 7 of them don't need to go to argument. I assume Justice Kagan's recused, but I would be interested. I think they probably should just let Justice Kennedy attend the oral argument alone.
I don't think they'll go for that.
You don't?
Yeah, I'm going to go on a limb. But, Roger, the only other thing I would say is, yes, as a theoretical matter, sure, they could do that. I'm sure there'll be briefs inviting him to do that. But if you sort of look at the kind of Roberts Court methodologically, I think they really like to condition people to the idea that a decision will be overruled. And, it's not to say that people kind of don't, the people who follow it don't sort of think that, Fisher will tell us something about sort of where the court is on this issue. But, I'd be a little surprised if they took that step here. And I think, in a sense, the Fredericks case I was talking about is a great example of, I think the methodology that they're more comfortable with, which is, in one case, you have, a bunch of justices essentially making the case for why a precedent should be overruled, but they don't do it. And then, then the next time the issue comes up, then it's teed up in a posture where it's all stare decisis, everybody's kind of really focused on that issue like a laser beam. So anyways, that's why I think I'd be a little surprised if they took the step here.
You could say, though, that kind of Roberts scenario has played out here already. That is, it's like in the Voting Rights Act Section 5 case. First they heard Northwest Austin, sort of a warning shot, then they went on and struck it down. Here, Fisher 1 was the warning shot. Fisher 2, they strike it down.
Well, we'll see. I mean, I don't disagree that you're probably right to read a warning shot into Fisher 1. It's just what are they warning you about? And I'm not, and I guess I'm not persuaded that what they were really warning you about was that, we're really gonna, turn this around, add clarity to the law here, and overrule these decisions, as opposed to just saying, okay, come on, Texas, you had the 10% plan, this is, you had the neutral alternative, and then you layered this on top of it, and you did it in a way that, isn't sufficiently subtle, which I think is part of the constitutional doctrine here. And so I think that they can, they can rule on a more case-specific basis. I just think that's more likely.
Yeah, I mean, this is why, I was not overly thrilled when they granted. I mean, Texas is not only 10% plan is unique, the actual admissions plan is gone. It hasn't been passed. I mean, they've moved beyond that. I think this was the admission year of 2006, but it's just a different, they're using something different now. So it's almost like they're just stuck on this particular case. So I don't know why they would go out of their way to make every other university freak out.
Other questions? Right here.
Hi, Lydia Wheeler with The Hill. Can you talk about what themes you're seeing on the Roberts course, or any type of certain cases that they're taking up term after term? I mean,
Well, the court does love the First Amendment. There's no question about that. And they always take a lot of First Amendment cases. And I think what, you tend to see in the First Amendment cases is the battle is really over, whether this is a true First Amendment case or whether it's one of the other kind of cases that, doesn't sort of make the cut as a pure First Amendment case. So a good example of a case where the court said it was not a pure First Amendment case is the Texas license plate case, where they said that the state of Texas, their speech was "Go Sooners" or "I am a Texas realtor." No, they said that, the license plate, including the part that has one of 335 different messages, is government speech, so the government could exclude the Confederate flag from the license plate. So that's like just one of many doctrines, government speech, student speech, different doctrines where they can sort of say we're not playing the sort of pure First Amendment rule. And, I think one way of thinking about the Fredericks case is, I think 5 justices will probably feel that's a pure First Amendment case. And 4 justices will probably feel that, what are you talking about? This is an agency fee that really doesn't directly implicate the First Amendment. And maybe it'll be 5-4 the other way around, but I think that's kind of what the issue will be. So, that's one. But just, the other one, I think if you're looking at a term, for this particular court term, and to be clear, the justices actually don't take these cases, so the term will be thematic. But nonetheless, if you look at the cases they've took, I think this is going to be a big term for class actions. There are a number of cases that implicate class actions in different ways. We talked about Spokio, but there are other cases, the Tyson Food case, this Campbell-Ewald case. There are a number of cases that will sort of make it, either substantially easier to bring a class action or perhaps more likely substantially more difficult to bring a class action before the term's over.
Yeah, I'm getting so old now that I'm taking the court in decades as opposed to years. It seems like when I started watching the court in the mid-'90s, we were, at least in the government's office, we were very much flooded with everything that happened with the legislation that was being passed, a lot in the criminal context. Then after 9/11, and then Ted Olson and Paul came in, we had a lot of time dealing with issues arising out of 9/11. This one, it seems like what we're heading into is some clashes between religious liberty and other types of liberty. Sort of abortion, race, guns are kind of always out there, but because of the legislation by states, I really think in my heart of hearts the court can't possibly want an abortion case. I just think that it's just they don't really want it, but they're going to have to take one. Yeah, what's weird about you sort of, I mean, I just know a little bit about them, and mainly because I'm from Texas, and I'm always amused to see what Texas is doing with my body, if I still live there. They're not so much on the substantive abortion procedures like they were, again, back when I was in the SG's office. It's now indirect routes with what kind of standards abortion clinics have to meet, how close do they have to be to a hospital, and do the facilities themselves have to function like, I forgot what the word is, but ambulatory surgical centers, and they don't. And apparently, Planned Parenthood has been in the news. I haven't been following it, but like a lot of people are like focused on it for some reason. So, but the other thing that's going on in the states, so Texas has one that's before the court, and I forgot, is it Mississippi? The Mississippi one is only entertaining because the state's view is, although there would be no abortion clinics in our state, there's always another state. And so it would be, I guess, more laughable if that were the state of Texas. But I think that's a hard argument. Texas is different. They're only going to shut down, I don't know, maybe 50, 75%. The other area that's going on in the state legislation is with the Plan B or partial birth abortion. I find that issue way more interesting and exciting because of what it does to the federal government, and it drags them in it. They're saying if you're going to do this procedure, you have to follow the FDA label, and the only way to do this procedure that everyone is doing it is off-label. And so it brings in one of Paul and my favorite areas of the law, First Amendment, but I can't imagine drug companies want to talk about their labels for abortion drugs. I can't imagine the federal government wants to talk about the fact that everybody is using this abortion procedure off-label. And the states are just saying, hey, we're just following what the FDA wanted. Don't look at us. And so it's interesting to see these people getting around the issues of abortion as opposed to just saying what you can and cannot do, which is at least when back in the 90s and early 2000s, those were more of the laws. So I don't know if that helps you on patterns, but it's just, I mean, I think people who watch the court will tell you it's always a function of the legislation Congress is passing and the programs the administration is doing. And so that's not surprising you see all the Obamacare stuff.
Well, with that, we've come to the end of our time. Please join me in thanking our panelists.
You're first.